Good morning, Ms. Brenner.
Good morning, Chief Justice.
Are you well and relaxed?
Yes, I am actually.
All right.
Yes.
Okay. Tell us why you believe you are ready for appointment to the High Court.
Chief Justice, I've been practicing attorney, notary, and conveyancer for the past 28 years. Including my articles, I've been an attorney in practice, hands-on, for the past 30 years. I have a wealth, breadth, and depth of experience in a miscellany of fields of law. For example, I acted for an engineering company. It's not in my papers, but I acted for a German engineering company in the Cape High Court, in which a damages claim was instituted for arising from a crane collapsing in Cape Town Harbour. And the case turned on an engineering term called a bending moment. And that necessitated my exposing myself to a little bit of engineering law. And then I was in Cape Town again in the High Court in a matter involving admiralty law and a fire that had actually taken place on board a marine-going vessel, which was on its way to Houston Harbour. That ultimately entailed the inquiry as to the circumstances under which absolution from the instance should be granted. I think maybe I'm going into a bit too much detail. I've also, as a notary public, done quite a lot of notarial documents, notarial servitudes, ANCs, antenuptial contracts, that is. And as a conveyancer, I have managed departments at several firms. At the firm Feinstein's, I was in charge of the transfer department, the bond department, and I also basically ran the litigation department there. It was during my tenure at Feinstein's that I accumulated most of the major exposure in major litigation. I also, for example, handled a matter based on a letter of comfort, which was supposed to be an actionable document, but it fell short of a deed of suretyship because it was issued by an overseas company during the apartheid era, and the overseas company did not want to reflect a deed of suretyship as a contingent liability on its balance sheet. So, but the wording of the letter of comfort was arguably sufficient to constitute a suretyship. I have also, since inception of my exposure to law, I have been involved in a lot of pro bono law. So when I started my articles in 1980, just bear with me, it's quite a while ago. In January 1987, I was given a cabinet full of personal injury matters. And they were given to the firm by the Legal Aid Bureau, and I regularly dealt with Pauline Lipson, who ran the Legal Aid Bureau.
And you've also acted in the High Court in Mafikeng, in
Yes.
Johannesburg, in Pretoria. You don't have any reserve judgment. You don't have any parthead matter. Is that correct?
Chief Justice, I have 2 reserve judgments.
To be written by other people, isn't it? Am I
No.
mistaken?
At
I
the
thought
time, I
one
filled
has
in
been
my-
referred to Judge Mlatlegi, another I forgot to which judge. Are they your own reserve judgments?
Well, as matters stand now,
Who's the scribe?
well, in relation to my application,
Yes.
what actually happened is that I handed down the one judgment, the
Yes.
Gauteng judgment, and then I took over handing down the judgment pertaining to, oh, just bear with me. The Boyson and Cause judgment, I wrote that
Yes.
one as well. So I wrote the Gauteng one, I wrote the Boyson one, and then
Yes.
Judge Molashlehi, I think it was yesterday, he handed down
Yes.
the Malema and RAF matter.
And are they not the June matters?
Sorry, Chief
when were they
Justice?
heard? When was judgment reserved? I seem to recall seeing June somewhere there. When was it reserved?
The Malema matter was reserved on the 5th of June,
Yes,
but that, yes, I wasn't the scribe there.
sure.
Gauteng was reserved on the 9th of June, and I think I prepared it in July, early July.
Yes.
And it was handed down in early July.
So you don't? Do you have new reserved judgments?
I do.
When were they
Chief
reserved?
Justice, a couple of weeks ago.
Not months.
No, a couple of weeks ago,
Yes.
Chief Justice.
All right. Is it an uphill struggle to produce judgments, or have you sort of found it a comfortable exercise to embark upon?
Chief Justice, I subscribe to the 10,000 hour rule, which is that the more you practice, the better you get.
Yes.
And so I've gone out of my way to write as many judgments as I possibly can. And believe it or not, I thoroughly enjoy writing
Yes.
judgments.
It's not a nightmare.
It's not a nightmare. I actually
Yes.
get excited and I lose perception of space and time. I get
Yes.
into a kind of alpha state when I'm writing a judgment because I'm a very focused person.
Thank you. JP?
Thank you, CJ. Good morning, Ms. Brenner.
Morning, JP.
Ms. Brenner, I think the CJ has touched on your acting stints, and that's my purpose here. I've put a spreadsheet in front of you. I don't know if you have it. That shows the commission all your acting stints.
Yes, JP,
Have you got it?
I've got it.
I see you're the one who's done the most acting stints of all the candidates that we're interviewing today. Do you see that?
Well, I haven't seen the spreadsheets of the other candidates.
Oh, okay. Take it from me. I won't lie to you. And you've also done work in the agent court.
Yes, I have, JP.
And when did you do it? Is it recently or a long time ago?
It was recently in the second term of 2017 in Johannesburg, and then in the third term of 2017 in Pretoria.
Yeah.
And then in the week just before I did urgence in Pretoria, I had the benefit of a 500-page urgent matter that was allocated to me.
Now, all I want you to tell the commission is your acting in the agent court has been recent, whilst you've acted for a long time. Do you know what the reason is for that?
JP, because I have never been asked to act in urgent court.
Oh, I see. Now, but if you study the roles, the rosters, it's unusual to put an acting judge in the agent court, isn't it?
Fairly unusual, yes.
Okay.
Yes.
But if an acting judge then finds himself or herself in the agent court, does it not say there's now confidence that the amount of acting stints you've done qualify you to sit in that court?
I would say so. I would say so, JP, and I thoroughly enjoyed myself in urgent court as well. Fortunately, there weren't that many matters. I think altogether there were about 20 stretched over the week, and in most instances I had the benefit of acquainting myself with the papers in advance of the hearings.
Right. And I see you've done a solid 9 weeks in the opposed motion courts throughout your acting stints.
Yes.
That's a fairly difficult court, isn't it?
It is a fairly difficult court, but what is really nice about it is that one has the benefit of the papers beforehand and heads of argument, so that the issues are delineated to a certain extent, and that's a very useful form of assistance in preparing for a post-motion court.
Yeah. I just want you to go back to the question the Chief Justice asked you about handing down judgments. Talking about you doing 9 weeks in the opposed motion and 9 weeks in the appeals courts. And when I look at your spreadsheet of judgments, the longest time you've reserved is about 5 months.
Yes,
Now,
that's correct.
How do you manage to avoid being in my dog box in terms of reserved judgments?
Because I love what I do when I'm on the bench.
Right. Okay.
I look forward to writing judgments, and I'm trying very, very hard to truncate the period of time between the hearing of the matter and the date on which I hand down judgments.
Yeah.
And my practice, the fact that I've had 78 weeks altogether since 2004, it's stood me in good stead, because I'm now able, it's starting to become quite effortless to write judgments. That's not to say that I don't apply my mind to the facts and that I don't research the law. Of course, that stands to reason. It goes with the territory.
In your practice, your own practice, the own litigation you've done in your more than 28 years experience, as well as acting, have you done any constitutional work?
No, JP.
You have not done it.
However, I am familiar with the Constitution. I'm familiar with a plethora of constitutional court judgments. In urgent court just a few days ago, the Paja Act and the doctrine of legality was argued in 2 review applications that came before me. And the Gajima case was mentioned, and the fact that that's going to the Constitutional Court. I'm also familiar with the recent judgment that was handed down by the Constitutional Court in the matter of the United Democratic Movement and the Speaker of the National Assembly.
Thank you, Ms. Brenner. Thank you, Chief Justice. I've got no further questions.
Many thanks, JP. MEC Lesufi.
Thank you so much, Chief Justice. Good morning, Ms. Brown.
Good morning, Commissioner.
You have declared in your documents that you have never been part of any community organization. What does that mean? It means you didn't have time, or you didn't see the importance of participating in community structures, take into consideration the history and where we come from as a country?
If you look at my provenance, I was brought up with the perception that my parents created, that work was everything. Both my parents worked throughout their entire lives, and they made it very plain to me from day one that if I failed any 1 year of my studies, that was the end of that. Then I'd need to stop studying. And you'll also notice that after I did my BA for 3 years, I then took a break of 2 years. That was to pay back my study loans. I worked at Barclays Bank for the two years after that. And then I resumed my studies at UCT, again with the assistance of study loans. I do not come from a privileged background. I am also a sole proprietor since I've started practicing on my own. And I have always been the sole breadwinner, all my working life. So it's been, and I have dependents as well. So it's been critically important for me that I've been kept hands-on in my business and done as much in practice as I possibly could. That's not to say that I haven't helped communities. During the course of my practice, I most definitely have. In the late 80s, I went to Ennerdale on several occasions. I was helping the Ennerdale Taxi Association on a pro bono basis. I'm currently helping to prepare the documents for Evangelical Outreach Ministries, which is based in El Dorado Park. I was in El Dorado Park just the other day, helping with fundraising. There are architects' contracts, building contracts, a contract with the owner of the land, all of which have to be drawn up. All of that is going to be done pro bono. So there are many other mechanisms by which I have actually contributed to the community. But I define myself by what I have done, more so than by what I have not done. And really, it's been time constraints primarily that have precluded me from belonging to any community organisations.
Justice.
Thank you, MEC. Minister?
Good morning, Ms. Brenner.
Good morning, Commissioner.
Just following on the line of questioning that the MEC pursued with you now, it seems to me that the angle from which you've made a contribution is in relation to providing your services pro bono, etc. But to what extent would you say you have contributed in the transformation of the profession itself by way of empowering historically disadvantaged persons in the legal profession itself? Have you had the opportunity?
Yes, I have.
And what have you done concretely?
I most definitely have. When I was acting in the criminal courts, and I basically started acting when I went on my own as a sole practitioner. When I acted in the criminal courts, it was encouraged at that juncture for acting judges in particular to appoint assessors. The assessors I appointed were primarily black assessors. I worked with Desmond Nkwanazi, I worked with Chris Mokaditwa, Pumlo Mojapelo Mofokeng, and they sat with me in most of my criminal trials. In practice, I have briefed Advocate Nazir Kassem from time to time, and I've taken advantage of the criticism that was levelled at me at my first interview.
Pardon me, Chief Justice.
5 years ago.
Pardon me, Chief Justice. I think the question really I'm trying to direct you to relates specifically to your area of proficiency as an attorney, practicing in a highly specialized, coveted area of the law that's probably highly lucrative. To what extent in that position have you been able to draw in, say, young, black, female, disabled, etc., persons from historically disadvantaged background to empower them, if at all?
I have been briefing Black Council, Commissioner. I don't know if you want names.
No, I'm not referring to you briefing counsel. I'm referring to you running a practice, possibly a lucrative practice, as an attorney over such a long period of time.
Yes.
In areas which are considered to be exclusive and specialized. To what extent have you been, if at all? Of
Yes.
course, if you haven't been, it's also okay. I just want to know if, in fact, I'm giving you the opportunity to
Yes.
share that if you...
Commissioner, the practice which was lucrative was not mine. That was Feinstein's. When I went out on my own, I had to basically scratch around for work. I never took any clients with me when I went out on my own. And
Pardon me, Chief Justice.
it was not lucrative.
Yes.
Comparatively speaking, Commissioner, it was not a
Apologies,
lucrative
Ms.
practice.
Brenner. You were part of that firm. I'm not sure what status you held in that firm.
I was a director.
And what influence you had.
No
but clearly the
influence.
firm itself was in a lucrative space, and you
Yes,
were
it
part
was.
of it. And I just want to understand if you played any role in that vantage position, if it was, to try and ensure that the firm itself actually played its role in contributing transformation. My apologies for keeping on interjecting.
No, that's-
I want to focus you to
Yes.
a specific issue.
Commissioner, there was a disabled candidate attorney who I recommended to my boss at Feinstein's, I was very keen on her and he was not keen on her. I had several conversations with him about finding candidate attorneys who were black. He was not interested. He was a kind of person who subscribed to the principle that it's my way or the highway. I had no bargaining position at Feinstein's. And then when I started out on my own, as I say, I actually couldn't afford a candidate attorney until 3 years ago. It was not a lucrative practice. It was a practice that basically just made me enough income to sustain myself and help to support my parents. But as far as my contribution to transformation is concerned, I do brief Black Council, and I refer matters outside of the parameters of my expertise to other attorneys. So, for example, for several years I've had a referral relationship with a criminal defense lawyer, and I'll say to my client, this is outside of my province of expertise. Can I refer you to Vicky Nkwashu, who is a criminal defense lawyer? Victor, I mean.
Anyway, that was not quite what I was focusing on, but it's fine. The second point I wanted to raise with you relates to your exposure to constitutional law. You've conceded that you haven't practiced in that field, but that you are aware of what's going on in the light of the jurisprudence that's emerging or evolving. You allude specifically to a specific case, a recent case in the Constitutional Court. Is there a specific reason why you allude to that court? Is there a particular constitutional principle that you drew from that court that was particularly, from that judgment, that was particularly striking for you? Do you want to share your perspective of it?
Yes. That case hinged on separation of powers sensitivity. The relief that was sought in the case against the Speaker of the National Assembly was overreach. It included a mandamus to the Speaker to conduct a secret ballot. And the Constitutional Court, in my mind, took full cognizance of the necessity for recognizing the principle of separation of powers. And it basically went so far as to spell out the legal position, but then it remitted the decision-making power back to the Speaker of the National Assembly.
Thank you, Chief Justice.
Thank you, Minister. Commissioner Mampuru.
Thank you, CJ. Thanks, Richard. Once again, thank you, CJ. Good morning, Ms. Brenner.
Good morning, Commissioner.
Are you well?
Yes, I'm great. Thank you. Are you well?
No, I'm more than fine. I just want to know, it is said that you obtained a certificate of good standing from the Law Society on 7 June 2017. There have been to date no disciplinary proceedings in respect of you. How do you define discipline in your own words? Number two, do you believe that success depends more on what you do or on whom you know? Thank you, CJ.
Thank you, Commissioner.
Discipline in the sense of disciplinary proceedings against a practicing attorney?
Yes.
Yes. I have while acting as a judge, I have dealt with several applications for the suspension of practicing attorneys or for the removal of practicing attorneys from the role. In all of those instances, they had perpetrated acts of chicanery. They had accessed their trust accounts without invoicing the clients or by producing fictitious invoices which weren't justified. And they had breached a level of trust which is implicit in the office of an attorney. An attorney is not just an attorney is an officer of the court. And if an attorney accesses his or her trust account without justification and without having raised an invoice, or that is one of the worst breaches of trust. It's basically, it's referred to euphemistically as misappropriation, but it's basically professional theft. And I believe that the courts should be very wary to guard the integrity of the legal profession. There are also disciplinary steps that are taken for example, failure to answer correspondence. Failure to answer correspondence is a sign of disrespect by an attorney, but it's, to my mind, it's not the sanction for that should simply be a fine or a reprimand of some sort. So there are various misdemeanors in the disciplinary process which may fall short of justifying a suspension or a striking off. I can answer the second question very, very easily because I'm speaking now from hard experience.
I'll appreciate that.
It's what you do. It's more what you do than who you know. As I say, I come from a very modest background. My parents weren't connected with people of influence. They were blue-collar workers. And I've got to the point where I am right now, I think, because primarily of what I do and not who I know.
Thanks, Ija.
Thank you, Commissioner. Judge President Hlophe.
Chief Justice, Ms. Brenner, briefly, do you have any views on how indigenous African languages, such as Setswana, Sesotho,
Yes.
Xhosa, and so on, can be developed so that ultimately they can be used in the courts in the same way as English is used today
Yes.
as a language of record?
Yes.
Thank you.
I firstly want to say that it is unacceptable for a South African, and I'm now speaking as a white South African. I was born in South Africa. I intend to die in South Africa. It's not acceptable for me not to have learnt a single black language. I accept that as the starting premise. I believe that the dialogue that's been created by Commissioner Malema, excuse the pun, is actually very constructive, because if two people can engage one another in the same language, there's a commonality there. There's a coming together. There's unity in diversity, as mentioned in the preamble to the Constitution. I believe that the failure of a lot of white people in this country to learn a black language comes from the racist apartheid heritage. It most definitely does. And attached to that, this arrogance of white supremacy. And if white people are committed to this country, I see absolutely no reason why they shouldn't try to learn a black language. And that the same principle should actually apply to all South Africans. So, in other words, a person who speaks Setswana should maybe try and learn Sepedi, or someone who speaks isiXhosa should, well, that's close to Zulu, should maybe consider learning Tsonga. But definitely, communication in one language will do a lot towards creating a level of goodwill between the citizens of this country. There's also a Chapter 9 institution in the Constitution, which is a commission for the protection of religion and linguistic skills. Maybe that commission would be a useful starting point to get the dialogue going. I really think that we should engage one another a lot more and get a profile out there about speaking one another's languages.
She hasn't answered your question? Okay. All right. Commissioner Norman?
Thank you, Chief Justice. Good morning, Ms. Brenner.
Good morning.
From the period 1991 to 2002, when you were with the Feinsteins doing specializing in commercial litigation, am I right?
Yes, that's
the
correct.
period that you were with them.
That's
Did
correct.
you, during that period, brief any black counsel?
No, other than Nazir Kasim.
Yes.
And the reason was, although I was a director, I held a nominal share, one share in that business.
That's not what I'm interested in.
I had no jurisdiction over who to brief.
Okay.
My boss, Ivan Levy, he was an autocrat, and he would call me into his office, and he would tell me in no uncertain terms, you are briefing so-and-so.
Yes, but you managed to brief Nazir Kasim.
Yes, well, that was with Ivan Levy's input.
Now, then the second question is in the matters that are listed in paragraph 9 of your application, which you have listed as matters where you were the instructing attorney, which you regard as very important matters, did you in any of those matters brief black counsel?
What page are we on, Commissioner?
Sorry, I'm using the electronic version of your, sorry, I'll just go up to the top. I'll tell you now. Page 52 of the paginated.
My page 52 is one of my judgments.
No, I'll get to it. Sorry, it just jumps this thing.
Is it the actual application, Commissioner?
No, yes, you've analyzed the cases that are of importance and those that you had written, and you then listed about 10 cases which it starts from page, thank you very much, Commissioner, goes from page 7. Sorry, I'm using the paginated bundle from page 7. Thank you.
Okay.
It would be under
Changweti,
paragraph 6.3.1.
yes, Changweti versus Minister of Home Affairs. No, the short answer is no black counsel were used.
Thank you very much. Thank you, Chief Justice.
That no black counsel were used.
Thank
and
you.
most of these cases were during, well, Changweti was when I was at Malamed and Hurwitz, and they decided who to brief.
Thank you.
And then Appleton
No, you've answered me,
onwards,
Ms. Brenner. Thank you. I've got the answer. Thank
I
you.
was at Feinstein.
Thank you very much.
Ms. Brenner, do you want to reconsider the reference to your former employer as an autocrat, or are you comfortable with that terminology? You don't have to. I'm just wondering if you're comfortable.
Chief Justice, several counsel would say to me that my boss ran a quasi-military operation.
All right. Okay. Commissioner Msomi?
Thank you, CJ. Ms. Brenner, there are 6 vacancies in Gauteng, and there are 10 people who have been shortlisted, why should we give you a nod?
Because I've got 78 weeks under my belt. My track record with writing judgments is relatively good, getting them out timelessly. The quality of the judgments would appear from feedback that I get from petitions that are dismissed at the Supreme Court of Appeal. They appear to be of caliber. There is one matter where leave to appeal was granted to the full bench, so that may still possibly be reversed. But most importantly, I've been hands-on in practice for 30 years, including my articles. I've been on the cutting edge. I've been interacting with human beings, particularly since I started my own practice. I didn't attract major work from large companies. I practiced from home, and I did work for the man in the street, really. And in a lot of instances, it was pro bono. In a lot of cases, if the client ran out of money, I would see the case through to its logical conclusion. I went to Grahamstown the other day in a matter where the father hadn't seen his son for 4 years. And for 2 years, I had acted for him on a pro bono basis. I also have a wealth of experience. So I'm an attorney, a notary, and a conveyancer. I've run a conveyancing practice, and I have been exposed to all different types of cases. I've dealt with a copyright case. I dealt with a case involving W.K. Hess and Agliotti. That was a matter involving fraud. I assisted the prosecution with preparing the papers for the criminal case, and I was involved in the ultimate arbitration there. I've been exposed to labour law, where Section 197 was pronounced upon. I dealt with the spontaneous combustion issue in the control chemicals case. FHP and Tehran dealt with the voidability of a sale agreement where not all of the trustees have signed a resolution to authorise the purchase of the property. Securefin and KPMG was a matter of great magnitude. It involved $40 million US. These were all at Feinstein's. And then I have also, I've also done a lot of insolvency practice. So
You are more than qualified.
I've had a lot of exposure to a lot of fields of law, and I've embraced that. So, for example, trademark law. I didn't know too much about it, but Judge Collipin asked me last year, could I take an opposed motion involving trademarks? And it was a pleasure for me to put myself on a learning curve and learn about trademarks.
Now, on the divide between what commentators and those who are in the know refer to as judicial activism vis-à-vis judicial restraint, on which line do you stand and why?
To my mind, an example of justifiable judicial activism would be the recent example of what happened in the Cape High Court, where two judges who had heard criminal reviews which had come from the magistrates' courts in Caledon and Montague and two other courts, noticed that there had been an inordinate delay in the prosecution of those reviews. In terms of Section 304 of the Criminal Procedure Act, certain judgments of magistrates must be sent on review to a High Court judge within 7 days. And these judges in the Cape High Court had actually observed that those judgments, that the reviews were not being sent timelessly, and some of them were only being sent 2 years down the line. And they made an order directing the magistrates to give them a list of all the outstanding reviews. That, to my mind, is it's constitutional because it's a case of access to justice being denied to the people against whom those judgments are granted, the conviction and sentence. But where judicial restraint and also judicial activism is sanctioned in the Constitution. The Constitution, of course, is the Supreme Court of the land, and the Constitution empowers a court. It gives a high court inherent jurisdiction, and the power in terms of Section 173, and then a power in terms of Section 172 to declare a particular section of a statute or a statute in its entirety to be unconstitutional, subject to subsequent sanction by Parliament or by the Constitutional Court. So there is a level of ability for some activism to take place, but all of that activism is reactivism as well, because the case has got to come before the judge. The judges can't go around looking for cases to handle. The dispute must come before the judge, and then the judge has those powers under the Constitution. As far as judicial restraint is concerned, what's become quite topical is that recent decision in the DA, the DA decision versus the President of the Republic of South Africa. It was an urgent review that was brought, and an order was granted that the record of proceedings giving rise to the firing of the Minister of Finance and his deputy, and the reasons should be given. That decision is moot, and I think ultimately it's going to land up in the Constitutional Court, because there is a perception that that judgment may have constituted judicial overreach. But ultimately it's going to depend entirely on the Constitutional Court, I would say, to delineate circumstances under which judicial overreach is not sanctioned, in circumstances in which there has been judicial overreach. The separation of powers doctrine is not an absolute doctrine, and it's a good reason. There's a good reason behind that, and that's because of the necessity for checks and balances, because each organ of state, that's the legislature, the parliament, and the judiciary, has to be reminded of the parameters of its powers. So
Commissioner, it's always open to you to indicate if you've been answered for the sake of progress.
Yes,
But if you still need more answers, obviously you are in charge of that leg of the interview.
No, I'm happy. I've been answered. I mean, perhaps on a lighter note, you have spoken about autocrats and quasi-military operations. Are you a quitter? Do you stand up to tyranny and autocrats? Thank you.
I think it was insensitive of me to call my previous mentor and boss an autocrat. I don't think it's very constructive. It's
CJ.
I apologize for that. I actually apologize for that.
Commissioner Malema.
Thank you very much, CJ.
Yes, Commissioner, I believe we share the same birth month. Well, that's at least something we've got in common.
Okay, no, thanks, CJ. I don't have any further questions.
Commissioner Schmidt.
Ngifuna ukufunda isiZulu. Ngizafunda isiZulu. Kuyashiza namhlanje. Libalele. Kodwa siyadinga no, water. Uvuma. Uphuza amanzi.
Akulungile. Commissioner Schmidt.
Thank you, Mr. Chair. I'd like to know why Mr. Mlema isn't asking his questions. But if you could page two of your nomination form, paragraph 6, you indicate a number of firms for which you worked in the past. I count 6, with rapid periods of 2 years indicating your article clerkship, then approximate 1 year thereafter at Melamed, and another 1 year thereafter with another 11 years where you apparently became a director. And then despite those time periods, and I would like to ask why those short time periods before you switch firms. The second question relates to why would you, as a director of Feinstein's Attorneys, which you worked 11 years, then go to Stan Fanneroff as a professional assistant? It does raise some questions which I think deserve some answers. Thank you.
Yes. I accept that it appears to show a level of instability. However, it was more a question of opportunities. At the first firm, I specialized in personal injury law. I moved to Malamed and Hurwitz because I felt that I wasn't being stimulated sufficiently. So, because basically I was primarily dealing with personal injury cases. At Malamed and Hurwitz, I came to learn a lot more about magistrates' court litigation, during the course of which I made a lot of appearances in the magistrates' courts. And then a friend of mine who used to work at Malamed and Hurwitz moved to Millezeeman and phoned me and basically headhunted me and said to me, I'll get even better exposure because Millezeeman was specializing in high court litigation. And then I decided to move to Feinstein's because I was offered a partnership at Millezeeman, but one of the requirements of becoming a partner was that I should sign surety for the overdraft, and I wasn't willing to stand surety for the overdraft of the practice. And then at Feinstein's, it was a lengthy period of time, and I moved to Stan Fanneroff because I felt that I needed to have a little bit more latitude in the way in which I ran the practice. And so that's why I went to Stan Fanneroff, and then I left because I had the confidence to start working on my own.
I think you've answered basically the gist of my question. The only outstanding issue seems to be the strange move from being a director at a firm to becoming a professional assistant.
Commissioner, I was a director in name only. I had no say in that practice, none whatsoever.
Thank you, Mr. Chief Justice.
Thank you, Commissioner Schmidt. Professor Ntlama.
Thank you, CJ, and good morning, colleagues. Sakubona nkosazana.
Sanbonani.
Okay.
Unjani?
Right. Oh, ndiyaphila inkosi unjani?
Nami unjani. Nami
I'm just
ngiyaphila.
wondering what the language of record is going to be.
Okay, be that as it may. Good morning, Ms. Brenner.
Good morning, Commissioner.
Okay. One of the responses from the law bodies is that your gender will reflect the gender representation of the judiciary other than your racial composition. Let's forget about that. But as a woman, what value will you bring to the judiciary? Let's forget about your race, let's forget about your gender, but as a woman, what value will you bring to the judiciary? Secondly, in your paragraph 10 of your questionnaire, you made reference to your diverse experience. And in relation to that, you also noted that in respect of these other fields, that what gives you an oomph in relation to your contribution to the field. My question is, the question that was asked by the JP, you made mention of the fact that you are familiar with the Constitution. So in the 71 weeks that you have been at the acting judge, how is that familiarity vis-a-vis the application that the judges are required by the Constitution to apply constitutional law in the respective areas in which you have been exposed to? How do you strike a balance between familiarity and the requirement to actually apply the Constitution in the fields in which you have been exposed or you are experienced? Thank you.
Okay. As a woman, yes, as a woman, I have done a lot of divorce work. I've practiced a lot of family dispute law. So I am in a position to identify with situations where women seek the comfort of the court in regard to aspects of maintenance, care, guardianship, and in relation to divorce matters. So as a woman, I would... Am I not answering the question?
Can I interfere on that one? Okay. I just wanted just your personal qualities as a woman.
My personal qualities.
Yes, not your
Okay.
technical abilities.
Oh, I see. My ability to interact with any person from any walk of life. I was taught very, at a very young age to respect everybody. And that's the credo that I've lived by all my life. And empathy. Empathy for people. And because my practice, my own practice has been one which attracts people with their own personal predicaments, I'm in a better position to empathize with them and to understand their position. And these are people who, as I say, are people of different races, different religions, different sexual persuasions, across the board. Really, I've worked with people from so many different arenas in life, and from a different economic strata as well. Does that answer?
Okay, so you can proceed to the second question.
My familiarity with the Constitution came to the fore as an acting judge. And that goes back to 2004 when Section 35 was implemented in several of the criminal trials that I handled. And then more recently, in unopposed motion court, invariably one will see foreclosure applications which have to comply with the provisions of Section 26 dealing with the right to housing. I also, in an opposed Rule 43 application the other day, had occasion to refer to Section 28 concerning the rights of children being paramount. And then in the urgent court a few days ago, there were two matters where PAJA was brought up, and a debate was raised as to whether PAJA is in a review of an administrative action, PAJA needs to be employed to the exclusion of a review based on legality. So that argument came before me as well. I'm also familiar with the Constitution insofar as the separation of powers is concerned. The Constitution itself doesn't actually spell out that there's a separation of powers, but there are sections in the Constitution which actually specifically delineate what powers the legislature has, what powers Parliament has, and what powers the judiciary have. That's basically what I can say about constitutional law. And access to justice. That's another aspect that I have carried through for my entire practicing career. Access to justice, helping people who are indigent and who cannot afford legal fees to solve their problems. And I've done a miscellany of different types of cases in regard to that kind of work.
Do you want another question? The third one, Prof. I must say, as you are asking
Just a
for it,
rephrase.
no, let me finish, please.
Sorry.
I have three more colleagues, and we beyond by 15 minutes already. Yes, sir, Prof.
I just needed to rephrase SJ because you said that it's only when she
No,
acted.
put it to her
Yes,
in the
yes.
interest of time.
Okay. Your earlier response on constitutional law, you said it's only when you started acting. So I wanted to find out whether your long years before you acted, whether Constitution had never ever came into your doorstep, of which you rephrased it with your last response. Thank you.
I never had an opportunity to deal with any constitutional jurisprudence before I became an acting judge. And I regret that, but that's unfortunately the way it worked.
Thank you, Prof. Commissioner Foree.
Thank you, Chief Justice. Morning, Ms. Brenner.
Good morning, Commissioner.
In the interest of time, I'll be brief. When you were last interviewed here in October of 2012, that's about 5 years ago, you were a sole practitioner.
I think bring it a bit closer, Commissioner. I suspect some might find it a bit difficult to hear you.
Sorry, I'll repeat. When you were last here in October of 2012, you were a sole practitioner. According to your questionnaire and CV, you are still a sole practitioner.
Yes.
Now, since you were last here, I see that there's been a break of roughly 4 years where you were not acting. That's according to the document that was distributed to us this morning. And you've been acting again basically since October of 2016 for a period of 28 weeks, so that's roughly 7 months. Now, when you were here in 2012, I took you to task as to how you managed your practice,
Yes,
being a sole practitioner
I remember that.
and
yes.
spending all that time on the bench. Your answer at that time was that you had to keep your practice afloat and that you had to deal with your practice after hours and early in the morning. In fact, your question was, your answer was, I had to do that. I had no option. I had to pay attention to both functions simultaneously. As a sole proprietor, I had no other option. I could not delegate the work to anybody else. When you were inter alia referred to the provisions of Section 11, You indicated that you were not aware of it. Now my question is, since October 2016, for a period of about 7 months, still being a sole proprietor, how have you this time round dealt with that?
Commissioner, I've addressed all of the issues that were raised at my last interview. Firstly, when I acted, I engaged a locum, and I actually started acting again in April 2016. So from April 2016 until recently, I was acting. In the period 18 April to 20 May 2016, I engaged a locum. Then in the period from October onwards, I had engaged a candidate attorney who became an admitted attorney in October 2016. And so she helped to run the practice. And one thing I can assure you of, in no uncertain terms, and my books are open for this exercise, I never earned 1 cent during that period of time. Not 1 cent.
Thank you, Chief Justice. Thank you,
I just
Ms.
might
Brenner.
mention that I can't find a counterpart to Section 11 in the Superior Court Act, but that doesn't derogate from what I've just told you, Commissioner.
Thank you.
Commissioner Booth?
Thank you very much, President. Good morning, Ms. Brenner.
Yes, good morning, Commissioner.
Thank you. Yes. Yeah. Unfortunately for you, I was born in September, not in March. So I'm going to ask you questions. My first one is on language. You were asked a question about language, which I'm not sure if you understood, but be that as it may, I think the question really is this. I don't want to make a long preamble, but I'll simply say this. Afrikaans in South Africa is, of the official languages, is the youngest language. It was only developed, and I've consulted some good authority here next to me, probably in the late 1800s, early 1900s. Even then, it was still diluted. But nevertheless, within 50 years of its existence, there were textbooks in it, there were medical textbooks, there were mathematics books, legal books, and all sorts of things. And that was because of deliberate intervention by the state and other agencies. Now, given that history that we have, what, in your view, bringing it back to our profession, what, in your view, can be done in the short term, in the medium term, and in the long term to develop the indigenous languages to such an extent that, A, you're quite right, people must learn the language and so on for social purposes, but that we should have these languages being used as language of record, where there's written material, and even being able to teach law in those languages. Obviously, that's a broader question of access to justice and all that. But what can be done practically to ensure that this happens in the shortest period of time?
That's a very interesting question, Commissioner. I think it must start with the government. I think government needs to become aware of the importance of recognizing our 11 official languages. And it's of cultural significance. Once again, going back to that precept, united in our diversity. We must embrace diversity, and we must embrace the different cultures, because that makes us the rich nation that we are today. From my point of view, maybe getting a voice out there, agitating for it, But I think ultimately maybe it would be better for an Act of Parliament to be enacted, which makes provision for the compulsory use of certain languages in certain areas. So, for example, in Limpopo, Sepedi would be spoken, or maybe Venda and Tsonga, and maybe at a provincial level. At the subordinate legislative level, it could also be considered. But once again, I think it's a question of dialogue and getting the word out there that it's not acceptable not to know an indigenous language. It really isn't. And as we speak, if anybody's interested, I will meet them for a cup of coffee in 6 months' time, and I promise you this, irrespective of the outcome of this interview, I will be speaking fluent Zulu.
No, thank you. That's commendable. What I really want to know is what should be done in the legal field practically. Like tomorrow, what should we do first to ensure that one day the indigenous languages in South Africa can be used as in court just on the same basis as English and what was happening to Africans. I mean, what should you do? You've sat in the criminal courts where this problem is probably most acutely visible. What can be done? What can we do starting next week to ensure that legal concepts are translated, whatever needs to be done so that one day we reach that point?
Is this from a judicial point of view, Commissioner?
That's why I was saying I'm confining it to our profession.
Yes, because it would be just judicial overreach for a court to just mero motu make the decision. Some parties would need to come to the court, and the court would then be empowered to adjudicate the dispute, perhaps by way of a mechanism of a declarator. I can't think of any other solutions, Commissioner. Okay. Maybe you can...
Thank you. All right. Thank you very much.
Assist.
Yeah, that's fine. All right. The second issue is about briefing patterns. I know you've withdrawn the kind of strong language, but whatever language you use, why did you stay in a place where there were signs of not giving you the space, and effectively you are being dictated to as to how you practice law, and even with an element of racism from being prevented from briefing black people and so on. Wasn't it your duty to leave a place like that rather than stick around? If you know, whether we use your descriptive words or others, but it was clearly a place where your professional latitude was being restricted.
Commissioner, I thoroughly enjoyed the caliber of work that the practice was attracting, and it kept me incredibly busy. So much so that I would be in the office at 5 in the morning, and I would leave the office 6, 7 o'clock at night, work on Saturdays and Sundays, most Sundays, and I wanted to be kept busy, and I wanted to learn as much as I possibly could. So it put me on a learning curve, and the learning curve went in an exponential direction. And then after 10 years, I decided to call it a day.
Thank you very much. Thank you, CJ.
Thank you, Commissioner Mpofu. Commissioner Kane.
Thank you very much, Chief Justice. Ms. Brenner, my question relates to Commissioner Mpofu's question, and it's this concern about whether you can hold your own as a woman. Now, most of the issues raised in October 2012 have been addressed. There was one point during your interview where you were asked something about your body shape. Now, if you were faced with that kind of question from anybody, even if they're in authority today, what would your reaction be?
My body shape has got toto kylo, nothing whatsoever to do with my aptitude.
Thank you. Thank you.
Thank you very much, Ms. Brenner. You're excused.
Oh, thank you, Chief Justice.